My Lord, with your kind permission, Daniel Manzo, appearing for the Law Society of Kenya and also for Wiper Democratic Party or interested parties. My Lord, if the orders are to expire today, then that will be at midnight. My Lord, the day is not yet over. We have applications in the afternoon. We are also affected by those orders. And my Lord, I suggest after the applications today, then we can discuss that matter before the court adjourns. I thank you, my Lord.
My Lord, Kibe Mungai, on behalf of the petitioners, there are two issues. You can see the senior, the team leader, Honorable Paul Mwite is not with us in the council. That is the first thing that we did in the afternoon. And as far as we are concerned, the matter is premature and the hearing and determination of that applications for the simple reason that the issue and an order had already been made that would be first dealt with by the court after its ruling of yesterday. Was the application for recusal. The other matters that relates to how we shall deal with the petition and we shall deal with all the applications, including the first application for conservatory orders. Those are matters that as far as we are concerned are supposed to be dealt with by the directions. By this bench, if it continues, or by any other bench. And therefore, the issue, my Lord, of a back and forth on what is to be had first, the court has already ruled on that. And I believe we need to stick to that. And I am lamenting that even as we sat here, because we have started a little bit late, there is some work we still needed to do with regard to the applications for the afternoon. So we would like any other businesses that is supposed to be done when, for example, Paul Mwite is in the afternoon, it will be dealt with in the afternoon. But my Lord, on the directions, the actual directions that have been given by the court, there are three things actually that we would like our reactions on behalf of the petitioners. Number one, my Lord, is that in giving these directions, we are understanding that the directions are being made pursuant to the Mutunga rules, the rules of procedure that are applicable. My Lord, under the rules of procedure that are applicable, a lot of the petitions that were filed before last Friday and the ones that were filed even on Friday last week are maturing their last dates for responses. My Lord, as we sit here, we are yet to receive any substantive responses to those petitions in either boards from the respondents. And that will have an impact on how soon we can be able to deal with the substantive matters. So my Lord, I would be expecting that as a further direction, everybody would be required also to comply with the Mutunga rules to the full. Now the second issue is that in all the petitions, the subject matter was the impeachment proceedings. The impeachment proceedings was culminating with the impeachment that was done last Thursday and the facts as they happened on Friday. A lot of these petitions would require some amendment so that they conform with the last petition, so that they are not termed as academic. So that, my Lord, towards that, the petitioners, including in the petitions where I'm participating, we had requested formally that we would want 3 days to ensure that any amendments are carried out, and then the respondents will indicate, they have been saying they can do things within a day or two. They will indicate how much time they need to do the responses, because, my Lord, that would assist in ensuring that whichever bench is going to hear and determine this matter would be able to give final directions, because, as we have said, these are interim directions. And number three, in order to be able to determine issues for determination, and these are issues that we deal with when we are doing pre-trial, issues for determinations that are essential in a matter with so many parties that would require close of pleadings. And the close of pleadings means that all the responses must be given. So that, my Lord, as far as today is concerned, I urge you respectfully that the first thing that can ensure we are moving forward is to ensure that the responses, in accordance with the Mutunga rules, will complete that journey. My Lord, if that is done, it is my view that we will be able to make some progress. In the meantime, my Lord, unless there is any other matter, because there was no other matter that was to be dealt with except directions, we would be happy to leave this place as soon as possible so that we are ready in the afternoon. We are most obliged.
Just before leaving.
Senior, because I'm on the same side, perhaps you can have some response on it. Your Lordship, for purposes of clarity and for purposes of not addressing the gallery anymore, permit me to draw the attention of counsel for the Senate to the notice of motion that was filed in respect to the conservatory orders that were granted. The judge sitting in Kirugwe, Your Lordship, was categorical that he granted prayer number C. Even as we await senior counsel Paul Mwejo to come in the afternoon, the wording of those prayers was so explicit that if my good professor had the opportunity of interacting with the document, which I believe he has not, would have come to the conclusion that the orders were drafted in this manner. That pending the hearing and determination, of this application inter parties, this honorable court be pleased to grant the orders that were granted. That is therefore to mean, Your Lordship, that question that senior counsel is raising has no sitting in the pleadings before you. Number two, Your Lordship, since we are here for mention and in the afternoon we are coming for the application for recusal, and I have had the advocates for the respondents insisting on the urgency to hear the application for setting aside, Your Lordship, it is important for the court to note that that application is not predicated on any response. And therefore, if I were them, I would be seeking guidance on how to file their replies. Your Lordship, I hope you are following. He doesn't seem to be following.
Why do you say that?
But
Why do you say that?
let me leave it at that.
Thank you. I think that is... Sorry, gentlemen. You cannot talk forever.
My Lord, on a very small issue, we do confirm that for His Excellency, the Deputy President, Gachagua, as the petitioner, we have not received responses from the respondents. So it is important that first of all we get directions for the filing of responses, because as we speak now, we have not received those responses from the respondents. Then number two, my colleague Senior Kibe has raised issues on filing of responses, so that in 522 we had given an indication that we might require to amend our pleadings, so that before the ruling that was delivered by this bench, there was indication that we might require to amend the pleading. That is in petitions in cohort number 1, so that if the court can grant us leave, within 3 days those amendments can be done. And thereafter, this can also probably affect in some petitions cohort number 2. So it is important that we get that particular direction. Finally, my lords, this proceeding, because of the nature, the way they are proceeding, would request that probably we be provided with sequentially the transcribed proceedings, so that in case we require the proceeding again at any time, those can be availed for purposes of good order. That is all.
May I say something?
With due respect to counsel, we did not intend to make today this hearing a long hearing. We have been courteous enough. We have read our directions, and and I think you should let us wait for proceedings in the afternoon.
Sir, I have something to say. Number one, the petitioners cannot approbate and reprobate at the same time. They are calling upon the respondents to file their responses. At the same time, they are seeking leave to amend the petitions. How would petitions that are to be amended be responded to when actually it should be the amendments that should come first and then responses follow? Number two, we brought to the attention of the petitioners that the interim order, one of the interim orders expires today, and the other one is the one we are complaining about, that it is actually aggrieving the respondents and should be set aside, the Kirogoya order. Therefore, we shall be delving into that as soon as it is practicable. And number three, the reason why we are here and from the day before yesterday is due to the applications that were filed on the 18th of October to set aside the ex parte conservatory orders. Therefore, that agency cannot be lost or cannot be clouded in whatever else they are saying. It is our position that we should actually proceed